Good morning. We are here this morning on Tuesday, February 28th, to convene the Labor and Public Employees Committee meeting. I am Senator Julie Kushner, Senate Chair of this committee, and due to the snowy conditions outside, a number of us will be registered to this meeting on Zoom. And so I do. Luckily, we've had a lot of practice with that in the past few years, maybe a little rusty, but I'm sure we can get through it well. And so with that, I will just ask if my co-chair, Representative Sanchez, has any opening remarks.
Thank you, Madam Chair. Look forward to our committee meeting. Hope everybody's safe and sound.
Great. Senator Sampson.
Thank you, Madam Chairman. Looking forward to a productive meeting too. And just a reminder that, we do have deadlines for the timeframes for agendas to be posted and that sort of thing. Yesterday, the agenda came out shortly after 6 p.m. I know there was some conversation about how it was uploaded at 5:59 p.m. I'll just point out that, the fact that we're waiting until 5:59 p.m. to put the agenda out is something that the majority does to limit the ability of the minority to be able to respond to the bills as it is. So the least I can ask for is that we actually make it by that time frame. And I look forward to a productive meeting today. And I'm hoping that we can begin to work together just a little bit better about communication on some of these items and working together in a way that is going to promote, a bipartisan result on these bills. Thank you, Madam Chairman.
Thank you. And I do appreciate your comments. We all are on many, many committees. I myself am chair of a committee, vice chair of 2 committees, and chair of a subcommittee, and on 3 other subcommittees. So it's just a lot. And so that often means that we aren't able to do the screening until late in the day. We'll try and move that up earlier, so at least our ranking members have access to the agenda earlier, as ranking member Representative Ackert did yesterday. We did get that posted at 5:58, and we have a screenshot of that to demonstrate that the agenda was posted before the deadline. So we do have rules for the general public that we have to follow, and the rule is that the agenda has to be posted by 6 p.m. the night before. So we will try and accommodate that, though, Senator Sampson. We really do, really would like to be in a situation where obviously we have bipartisan support, and also that we are not putting anyone on the spot. So appreciate your comments. Representative Ackert.
Thank you, Madam Chair, and I believe a lot has already been covered before this, and I'm ready to get to work. Thank you.
Thank you. Okay, so we will start with item number 3 on the agenda, proposed bills to be drafted. The first bill is proposed House Bill number 5033, an act concerning compensation of incarcerated individuals.
Rep. Hughes, so moved.
Second.
So it's been moved and seconded. Is there any discussion?
Just Rep. Ackert.
Okay, so let me just suggest that Cameron is in the room. So if there's someone in the room that would like to speak, if you could raise your hand, Cameron will alert me. There's also hands raised on the screen here that I can see. So in this case, let me start with Rep. Ackert, and then I'll go to Senator Sampson.
Thank you, Madam Chair. And I would imagine that, I'm going to support this as it moves forward. I'm sure this is probably going to have to go to appropriations in some manner. Is that correct, Madam Chair?
That is correct. And I believe appropriations has been notified that we have this bill coming forward.
Thank you.
Senator Sampson.
Thank you, Madam Chairman. This is proposed House Bill 5033, an act concerning compensation of incarcerated individuals. I understand that the purpose of this bill is to try and give folks that are leaving a correctional facility an opportunity to re-enter society. And I think that's a laudable goal. My understanding, though, is that this is going to increase the amount that they are paid, so they have some funds. I don't know that, changing them from $5 or $10 a week to $35 a week is going to make someone more prepared to be able to go back into the world. But I get the point of it. The question I have is, where's this money coming from, Madam Chairman? Is this coming from the general fund? Is it coming from an existing DOC appropriation? Can you let me know where the funds come from?
I think we could certainly ask OPM. I don't want to speak out of hand. I imagine it's the general fund, but it could be that there are existing funds. I know that there will be a fiscal note on it. It will go to appropriations where it will be thoroughly vetted.
I appreciate that answer, Madam Chairman. Thank you. And as was indicated in the beginning of the meeting, I'm okay with a voice vote on this item. Thank you.
Great. Is there any other discussion? Seeing none, this will be by voice vote. Please, everyone, unmute yourself. Be ready to vote. And so, all those in favor?
Aye.
Aye. Any opposed? The motion passes. Next on the agenda, proposed House Bill number 5856, an act concerning state marshals' health benefits. Is there a motion?
Hughes, so moved.
A second?
Second.
And moved and seconded. Is there any discussion? Senator Sampson.
Thank you again, Madam Chairman. This is an act concerning state marshals' health benefits. I know a number of the state marshals, and they're fine people, and I know they work hard, and they have a dangerous job, and I applaud them for their efforts. And I certainly can understand our desire to improve their health care. I just want to make sure I understand this properly, though. We're talking about state marshals and not judicial marshals. And my understanding is that state marshals are independent contractors. They are hired sometimes by the state or maybe by individual attorneys, people that are parties to lawsuits. Is that correct, that they're independent contractors? They're not currently state employees? Through you, Madam Chairman.
My understanding is they are not state employees. There are a lot of conditions that go into whether or not someone is an independent contractor. I have not gotten enough information to give you a definitive answer on that, but they certainly are not considered state employees for purposes of the healthcare and other state employee benefits that we're very well aware of. They're unusual in that respect. We are aware that there is at least one other group of employees that are in the state employees health plan that are not considered state employees. This is like that. I recognize your concern about them being independent contractors, and I think that question has been raised, and something we're going to need to look at is, as we draft this bill, is there a threshold of employment that we're looking for to make sure that there is a nexus between their employment and the healthcare program that we would be putting them under.
Thank you very much for that answer. I mean, at the end of the day, my support for such a policy is going to depend on what the bill language ultimately says. And I understand that our vote today is a vote to draft. I can be supportive of that. Although I want to reserve the right to, bring to the committees, any concerns that I have about the ultimate drafting of the bill. And again, unless there's objections from anyone else, I'm fine with a voice vote on this item as well. Thank you.
Cameron, is there a hand in the room?
There is a question from Representative Weir, I believe.
Representative Weir.
Yes, thank you, Madam Chair. In addition to the concerns raised by Senator Sampson about the judicial marshals being, the state marshals being independent contractors, it's also my understanding that they don't just work for the state, that they are working for private attorneys on private legal matters, civil matters, not criminal. Is that your understanding as well?
My understanding from the testimony we heard is that is the case, that they could also be working for a private law firm or other employer. I do want to point out that we have probably many, I venture to guess, a whole lot of state employees that also have private employment. I think the real question that comes down and that we're going to have to look at in drafting the bill is, again, is there sufficient amount of time that they have that connection to the state of Connecticut that we would want to supply them with health benefits? And I think that's going to be something important to look at in the drafting of this bill. So, I mean, if it's somebody who's working one day in a month, I don't think it's our intention to offer health benefits. But if it's somebody, as we heard much testimony, that there are people who are working every day for the state of Connecticut as the state marshal, and I think that's that's certainly something that we want to address. I recognize it's going to come down to the drafting of this bill for some of the people on our committee, and probably for most of the people on our committee.
Okay, thank you, Madam Chair. And I guess that, I recognize too that there are state employees who also have other forms of employment. But in this case, these are not state employees. And that, coupled with the fact that they also perform work for other parties, is a concern to me. Again, I will need to see the language, but I want to raise that concern today that, these are not state employees. You really have two criteria that would tell me that would bring this to make this a concern of mine, that they're not state employees and they're doing work for entities other than the state. So anyway, I would need to see the language, and I can vote to move this forward today with those concerns noted. Thank you, Madam Chair.
Thank you. So are there any objections to a voice vote? Seeing none, then we'll be taking a voice vote. Prepare yourself to vote. On House Bill 5856, all those in favor? Say aye.
Aye.
Aye. Any opposed? The motion carries. Next on the agenda is proposed House Bill number 5859, an act concerning employment of individuals in agricultural labor. Is there a motion?
Rep Hughes, so moved.
Second, Eckert.
Been moved and seconded. Is there any discussion? Seeing no hands, then is there any objection to taking a voice vote? Hearing no objections, then we'll take a voice vote on this bill. Proposed House Bill number 5859. All those in favor?
Aye.
Opposed? Next on the agenda, it passes. Next on the agenda, proposed House Bill number 6362, an act concerning the advanced energy companies and the workforce. This is a bill, as I understand it. Again, it will come down to the drafting, but the explanation we were given is this is a bill that would help the state, would qualify the state to be able to access certain federal funds. We're still tracking that down, I believe, but we wanted to keep this alive, and then that's why we are asking for the committee to pass on a drafting a bill. So did I take a motion? Is there a motion?
So moved.
Rep Hughes, yeah, seconded.
Okay, it's been moved and seconded. Any discussion?
I believe a voice vote's fine on this one, Madam Chair. Rep Eckert.
Thank you. So we will take a voice vote. If you could ready yourself. All those in favor, say aye.
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 Any opposed? Okay, great. Moving on, that it passes. The next item on our agenda is proposed House Bill number 6462, an act concerning the recoupment of state costs attributable to low-wage employers. Is there a motion?
Rep Hughes, so moved.
Second.
And it's been moved and seconded. Is there any discussion? Senator Sampson.
Thank you, Madam Chairman. You were doing so well. But this item on the agenda, I have to tell you, is something that really bugs me. the fact of the matter is that, the state of Connecticut makes, labor policy. We have established a minimum wage and standards for work and so forth. And I don't believe that the companies that are targeted in House Bill 6462 are doing anything wrong. And I do believe that this policy is it smacks of class warfare and wealth redistribution and everything that I think is damaging Connecticut's economy and making us less attractive as a place for people to live, to work, to retire, and to certainly invest in a business. And it's bad policy. I don't think it's worth drafting, and I will be a no vote today. Thank you, Madam Chairman.
Thank you. Cameron, is there a hand in the room?
We have questions from both Rep. Ackert and Representative Weir.
So we'll start with Rep. Ackert.
Thank you, Madam Chair. And very similar concerns. We've been, the state has moved forward with raising the minimum wage. And a lot of these franchisees, and that's the big thing, is a very, very encumbersome group of people that we're talking about, not just the big box stores that we like to target, but franchisees are some of the small shops that have opened up to sell their goods and or sell a food. They're already struggling at the cost of everything, whether it's raising a minimum wage for an entry level worker, or the cost of their goods has gone up drastically. And this here, also, as we know, we understand that we may be pulling out not-for-profits out of this, which I believe is necessary. But I think overall, I don't believe this bill should move forward. So I will be a no on this.
Thank you. Representative Weir.
Thank you, Madam Chair. I am concerned with the language and the intent of this bill. We certainly want to encourage people to work. And this, to me, seems like we're discouraging people to work. These are people who are getting up, going into work, producing. They may be using some state benefits, but they're getting up and they're producing. And just last week, I saw a study on income inequality where the lowest fifth of the population subsiding almost entirely on subsidies has about the same income as the fourth quintile, basically the fourth level, who are going into work and taking advantage of some subsidies, and their income is almost the same. And I think this language is going to penalize those people who are going out, trying to make a difference, trying to have some dignity by working, and going to encourage them to stay on subsidies rather than getting out to work. So, and I'm also concerned with penalizing an employer, regardless of the size, producing job opportunities in the state. And now somehow we're going to add another fee, another tax. So I will be a no vote for those reasons. We want to make Connecticut more competitive, not less competitive. I believe this is going to be damaging to the state economy. Thank you, Madam Chair.
Thank you for your comments. Are there any other hands in the room? Seeing none, we'll have a roll call vote on this item, and we will be keeping votes open today. And we'll announce at the end of the meeting the hour deadline we will have for voting. So Cameron, if you'll call that bill.
A roll call vote has been requested and a motion made and seconded on agenda item 5, House Bill 6462, an act concerning the recoupment of state cost attributable to low-wage employers. This is a vote to draft. Senator Kushner.
Senator Kushner votes yes.
Representative Sanchez.
Representative Sanchez votes yes.
Representative Wilson.
Representative Wilson votes yes.
Senator Cabrera. Senator Sampson.
Sampson is no.
Representative Ackert.
Representative Ackert, no.
Representative Hall. Representative Hughes.
Representative Hughes, yes.
Senator Lesser. Representative Weir.
Representative Weirs, no.
Representative Yakarino. Thank you, Madam Chair.
Thank you. As I mentioned, votes will be held open. Next item on the agenda is proposed Senate Bill number 21, an act prohibiting employers from charging employees for training costs upon separation from employment. Is there a motion?
Rep Hughes, so moved.
Is there a second?
Second.
It's been moved and seconded. Discussion. I see Senator Sampson.
Thank you, Madam Chairman. This is Senate Bill 21, as you just, I'm sorry, is that right? Yeah. Senate Bill 21, right? An act prohibiting employers from charging employees for training costs upon separation from employment. The title, is a little bit misleading in my opinion, because it only speaks to, this part of the relationship. The fact of the matter is that there's another part of the relationship in a lot of circumstances, which is that employers are offering training and education as an enticement to employment and as a mutual benefit for both themselves as the business owner and also for the employee. And the creation of this type of policy, to me, first off, it flies in the face of the notion of private contracts. It ignores the fact that, we are the representatives of our constituents. And if they want to enter into such an agreement, then who are we to tell them not to? And more important, it's going to have a disastrous effect in certain industries. Certainly, there are small manufacturers across this state who are having a difficult time tracking down skilled employees. We're losing them to other states because our business climate in Connecticut is less than desirable based on policies similar to this one. And this will not help because these employers, put out an offer effectively to take someone who maybe just got out of high school or, has not had a skilled type of employment before. And they offer them a career and sometimes a job that can pay them six figures to work in, their facility. And all they're asking for after making such a significant investment is a commitment from that employee that they're going to stay employed with them for some period of time. And usually that's in contract form. So it is, agreed to. The terms are negotiated between the employer and employee, and they are agreed to. And I don't know why we would want to stand in the way of people that are offering education and training to employees, because that's effectively what this does. Now, I understand when Senator Duff testified before the public hearing, he may have been referring to entry-level jobs and a different type of thing. Well, that is worthy of debate, I imagine, but that's not what this proposal seems to go after. This seems to go after career level employment and preventing an opportunity for someone to receive that kind of training in exchange for contractual obligation, which only makes sense in the current environment in this state. I really want to caution the committee about doing this bill. If it's drafted in a way to reflect only entry-level, low-income opportunities and to prevent, harsh terms in an employment agreement, okay, well, I'm not saying I'm going to like it, but I can understand that. But this broad brushing the elimination of real opportunities is highly dangerous. I encourage the committee members on both sides to think hard before voting on this item. It's not a road we should go down. We should be working on legislation that is going to tell employees and employers that they are welcome in this state to enter into any kind of agreement to produce and create opportunity and wealth for themselves and others. Thank you, Madam Chairman.
Thank you, Senator Sampson. I also am aware that Representative Acker would like to speak on this issue.
Thank you, Madam Chair. Very similar comments in a way. Also expanding it to our towns and municipalities also. One of the things that we've really encouraged our businesses and financially encouraged them in terms of tax reductions and that they should be bringing in people and creating a training program, whether it's an apprentice or a paid intern, to bring them on staff, invest a good amount of money in them so that they can make a better way in life, better income, better benefits. And our municipalities are also concerned about the cost to them if they do the same, whether it's a CDL driver that they're sending to school or a local police officer that is coming on board and getting that training. So this could open up some issues with towns hiring and only hiring trained people rather than hiring those that need to be trained. And that's my biggest concern, is that somebody bringing somebody in, I bring in people into my small business and invest in training. They come in at entry level. They may have some minor training, but overall, they don't have the training necessary to completely do the job that needs to be done unless I give them the tools to train them. So, and many businesses are the same. So on that note, I'll be voting no on this.
Thank you. And I believe there are no other hands in the room. Seeing no other hands.
Representative Weir has a question, I believe.
Okay, great. Representative Weir.
Thank you, Madam Chair. Wanted to echo a couple of the statements made by both of my colleagues. Training costs are expensive for the employer, and they are also an opportunity for the employee to advance and gain skills that he or she may not otherwise have an opportunity to learn. And so you've got the employer who's willing to invest in that employee. I know in my days as an employer, we've there may be a class that's a training course that is beneficial. You want that employee, it's necessary for the employee to advance. And that class may be held in Florida, Ohio. We've sent employees to New Jersey. And so you're not talking just the cost of the class, which may be a few $1,000s. You've got travel costs, you've got meals, hotel, and all these other expenses that may be wrapped up into 3, 4, 5 days of training. And when that employee returns, he or she has skills that were not there before that training. And the employer has made an investment similar to many other investments that go into making a successful business and a successful workforce. So to then say that there's a certain trust between that employee and the employer, and most of the time, I would assume that this agreement, to Senator Sampson's point, it's made in advance. There's an agreement made where the employer trusts and invests in that employee, and the employee trusts and invests to continue investing in their own career with that employer. And I'm afraid that we're interfering with that relationship with this piece of legislation, or even the consideration of this concept that we're interfering. This legislative body really has no business interfering in what a private employer and a private citizen can and cannot engage in. I think we're affecting that trust relationship. Hiring a new employee is expensive. Startup costs, HR costs. All that stuff, there are costs that go into it, and I'm afraid that if we add another layer of burden on employers, we may hamper investment in employees, hamper hiring at a time when we need people to be entering the workforce. And I would just simply like to close with, when people go to college or other forms of training, the student pays for that training with the hopes that when they come out, they're going to have some skill that they can use in the workplace that's relative to the education they received. And those are, nobody talks about, people coming out of college with, or in this case, we're not recognizing that, tens of thousands, hundreds of thousands of dollars in debt. And here we have an opportunity where the employer wants to invest in the employee with no out-of-pocket cost to that employee, other than a commitment to stay on for a certain period of time, and not come out with a bunch of debt that a lot of college students that we see today. So I see a correlation there, or some sort of comparison that could be made We're not after the colleges and universities demanding that they produce students that will be automatically competitive in the workforce. Otherwise, you get your tuition back. There's no such guarantee. So I would like to see that comparison, be moved to the private sector where you've got two willing parties willing to invest in each other. Thank you, Madam Chair.
Thank you for your comments. And I'm just checking. I don't see any other hands at this time. I do want to make one comment. I think that the comments made by Senator Sampson and the representatives are worth consideration. And hopefully when we're drafting this bill, that there will be some reflection in the way the bill is drafted that will hopefully make it possible for you to support this when it comes to our committee for vote. Thank you for those comments. And I think we're ready to vote. So will you call the roll? Cameron, will you call the roll?
Certainly. A roll call vote has been requested with a motion made and seconded on agenda item 6, proposed Senate Bill number 21, an act prohibiting employers from charging employees for training costs upon separation from employment. This is a motion to draft the bill. Senator Kushner.
Senator Kushner votes yes.
Representative Sanchez.
Representative Sanchez votes yes.
Representative Wilson.
Representative Wilson votes yes.
Senator Cabrera. Senator Sampson.
Sampson is no.
Representative Ackert.
Representative Ackert is no.
Representative Hall.
Representative Hall votes yes.
Representative Hughes. Senator Lesser. Representative Weir.
Representative Weir, no.
Thank you, Madam Chair.
Thank you. And as you mentioned earlier, votes will be held open. The next item on our agenda is proposed Senate Bill number 151. Is there a motion?
So moved.
Is there a second?
Second.
It's been moved and seconded. We did hear testimony on this bill, and I would just like to advise the members of the committee that it's a new concept that we're taking up for the first time this year. As far as I understand, certainly in recent times, there hasn't been a bill proposed like this. So just to give a heads up to committee members, we are asking for a vote to draft, and we are looking to vote this to draft this as a study bill. So that may affect your views on the bill. So I see that there must be a hand in the room because I see Cameron Clark has his hand up.
Representative Ackert has a question.
Thank you. Representative Ackert.
Thank you, Madam Chair. More of a comment because from our discussion last evening, I do support this to be drafted and look forward to it to come out as a study bill because I think that it is a topic that I'd like to hear more about. And I think the only way to do that is through an actual study. But unfortunately, I hope that the study actually, is accomplished if we do move this legislation forward. From both chambers. But at this point, I'm going to support it and look forward to the language that is put into this bill. Thank you, Madam Chair.
Thank you. Seeing no other hands, I will ask if there's any objection to a voice vote. Hearing no objection, then we'll be taking a voice vote on this bill. Will you please unmute yourselves? All those in favor?
Aye.
Aye.
Any opposed? The item passes. The motion passes. Next on our agenda is proposed Senate Bill number 489, an act limiting the days an employer can mandate an employee to work. Is there a motion?
Rep Hughes so moved.
A second?
Second.
It's been moved and seconded. Any discussion? Senator Sampson.
Thank you, Madam Chairman. The title of this bill says an act limiting the days an employer can mandate an employee to work. Just want to remind the committee that I don't believe the title's accurate. The fact of the matter is that we have at-will employment in the state of Connecticut, and no one can force anyone to do anything. Thankfully, we don't live in an era where people have indentured servitude or anything like that. It is a free negotiation between the parties, and there may certainly be tough employers who demand a lot of their employees, and the employees don't appreciate that, but that's why they have the opportunity to look for other employment. The more important factor is not about that situation. It's more about the situation where both the employer and the employee want to enter into an arrangement. And we are, again, drafting a policy that interferes with the freedom of our constituents, the employee and the employer, to make their own decisions. I don't know why this committee feels like they have the right to continually do this, but it's like almost every bill says that the contract agreement between the employer and employee that they are making of their own free will and accord can't exist. If these types of bills continue on and they make it to the floor, I can tell you we're going to have a long lesson about how free markets work and about the benefits of capitalism and why we live in the best place in the world as a result. The short version is simply that when you start to tell people they can't engage in producing value in the world, goods or services, by making an arbitrary and artificial impediment to a voluntary agreement, you end up with less production in the world and you end up with a lower quality of life. I don't think anybody on this committee wants to see that. So I don't understand why bills like this come forward. I get the notion we want to protect employees, and if it's a legitimate protection, that's something I could find my way to support. But this is not a protection. This is a restriction on the employee's freedom to engage in certain activity if they so choose. I'm going to vote no today, Madam Chairman. We should not go down this road. It is just another bill telling people that we do not encourage economic growth and expansion in Connecticut. It's a bad idea. We need to go the other way.
Thank you. I do want to respond briefly. I know Senator Sampson, you and I don't always agree on our approach to the world, but I do think that it's worthwhile to point out that I believe the intention of the original statute that is already in place was to give people a day of rest and to require employers to give people a day of rest. And that's something that's been in our laws for a very, very long time. And it's there not just in terms of employment, but it's been there in terms of, selling certain products. And I think that was the intention. And, most likely most people thought there would be a work week that was Monday through Saturday, and that people would have a day of rest on Sunday. I think this is really a function of a very small number of employers and small number of types of employees that end up, because of the way work weeks are scheduled and the way the statute currently reads, working up to 12 days without a break. And I think that that's what's being addressed here. And clearly there was testimony by the proponent of the bill that this doesn't say that someone couldn't voluntarily work those 12 days in a row, but it is to make sure that no one is mandated to work. And, it goes to questions of safety and a lot of other things. So, I know that probably did not persuade you in any way. And I recognize that, but I do think that there was some rationale about this being an important way to clarify the current statutes. I do see that there's another hand.
Madam Chairman, forgive me. Since you answered my question, I have a follow-up question based on your response, if that's okay.
Yeah, I was going to come back to you, but it's fine. Go ahead.
I'm sorry. Well, you mentioned that the intent of the proposal is not to prevent someone who voluntarily wants to engage in that activity. And I just don't know what's the purpose of the bill then, since the terms of employment are determined by the employer and employee voluntarily already.
The intent would be that you couldn't fire someone because they refused to work 12 days in a row.
All right. Well, I appreciate that, although it seems to me that you just, that wasn't the answer to my question. My question was, you said if the employee wants to do it voluntarily, the bill's not intended to prevent that, but that's the current law. So I just don't understand, but I'll look forward to see what the bill looks like when it's drafted. And I stand by my comments. Thank you, Madam Chairman.
Great, thank you. Representative Hughes?
Yeah, thank you, Madam Chair. I just wanted to clarify some of the things you said. This is especially in healthcare, especially in nursing, where they may be mandated to work 12, 14 days in a row. That's really unhealthy for patient care, also for the employer, because of the technical definition of work week. And this is a technical change. Of course, if an employee wants to work 12 days in a row, they are free to do so. They just can't be mandated. This is really technically changing the definition of work week to mean mandated, more than, maybe 10 days in a row or something like that. It's limiting that. It's really for safety reasons. And that's where, kind of the whole free market capitalism in healthcare falls apart a little bit, because we really do have to protect both employer and patient safety. And that employer knows best what their limits are. And we want them to be able to do their limits and keep to a reasonable number of days that they work in a row and be safe. And if they want to work more, they can.
Representative Hughes, I think you may have misspoke. I want to make sure you're saying that the employee knows best their limits, as opposed, it came across.
Did I say? I'm sorry, I meant employee. Yes, employee knows best their limits, and it allows them to be able to have those boundaries. Yes, thank you.
Wanted to give you the opportunity to make sure we all heard it correctly. All right, I do see Representative Acker.
Thank you, Madam Chair. And, the senator came in and did an excellent testimony for the career field that she's in. And it's understandable. And I have a similar family member in that career field and completely understand it. But it overlaps into every career. As I look through the testimony on how many different groups have opposed this, they're not bad employers. They're not bad employers. They're just individuals that have to get a job done at times. And understand, obviously, if it has a negative impact on an employee, that they should be able to identify that, or the employee should speak up and say, listen, I know it's tax season and I'm a CPA and I understand that there's a deadline that's pretty much solid in taxes, or it's a utility contractor that, is deployed out to help us in this area. They become local employees here in the state of Connecticut that are working on our behalf to get our power on. So there are areas that could overlap that we may not have unintended consequences by this legislation. So I'm torn in a couple ways in terms of certain careers, but in areas that they may need to work extended hours and understand that that we need them on the job. So for those, I'll continue to listen to dialogue and probably not support this when it comes to legislation.
Thank you. Any other hands? And I'm assuming we're going to do a roll call vote on this bill. So Cameron, please call the roll.
A roll call vote has been requested with a motion made and seconded on agenda item 8. Proposed Senate Bill 489, an act limiting the days an employer can mandate an employee to work. This is a motion to draft. Senator Kushner.
Senator Kushner votes yes.
Representative Sanchez.
Representative Sanchez votes yes.
Representative Wilson.
Representative Wilson votes yes.
Senator Cabrera. Senator Sampson.
Sampson is no.
Representative Acker.
Representative Acker, no.
Representative Hall.
Representative Hall, yes.
Representative Hughes.
Representative Hughes, yes.
I'm sorry, Representative Hughes, I didn't see your face there.
Representative Hughes, yes.
Thank you. Senator Lesser. Representative Weir.
Representative Weir, yes, pending further discussion on this.
Representative Yakarino. Thank you, Madam Chair.
Thank you, and we will hold votes open. Next on the agenda is proposed Senate Bill number 831, an act concerning amusement parks and the employment of individuals at least 14 years of age. Is there a motion?
So moved.
The moved, is there a
Second, Rick Backert.
Representative Acker second? Is there any discussion? Representative Hughes.
Yeah, I'm going to raise some concerns about this bill as a former camp director for young people and hiring staff. I just think it's a really bad idea to hire staff 14 years of older in terms of supervision and liability. And so I'm sorry, I can't support this bill. I'm going to be a no, and I request a roll call vote.
Thank you, Representative Hughes. Thank you for your comments. Any other comments? Seeing none, a roll call vote has been requested.
I believe Representative Weir raised his hand.
Oh, I'm sorry, Representative Weir.
Yes, thank you, Madam Chair. And this is a bill that interests me because we hear about how you can't find employees. This is an opportunity, I think, to allow young people to gain some experience, to dip their toe in the water of, starting to work. We allow it. I hear Representative Hughes' concerns about young people, but we allow it and encourage it in an agricultural setting where young people have for hundreds of years worked on farms around heavy equipment, large animals, doing physical labor, and we encourage that today. When I was growing up, a lot of my peers, when you couldn't work at a grocery store, you couldn't, we weren't old enough to scoop ice cream or do some of those things. Picking tobacco was an opportunity for kids who I knew in Glastonbury, East Hartford, where the tobacco farms were there. And it was an opportunity to it was hard labor, but it was an opportunity to earn a few bucks and learn about work ethic. And so here, that's still approved and encouraged today in an agricultural setting. And here we have an amusement park setting where, under proper supervision, where the language clearly says, menial, safe jobs, where they can learn work habits. For that matter, I would hope that we would, as a committee, vote to at least hear more about this, as we've done with some of these other bills. And let's see what the language says before passing judgment on this bill that I think will encourage young people to join the workforce. Thank you, Madam Chair.
Thank you for those comments. Any other hands? Seeing none, then I'll ask the clerk to call the roll.
A roll call vote has been requested with a motion made and seconded on agenda item 9, proposed Senate Bill 831, an act concerning amusement parks and the employment of individuals at least 14 years of age. This is a motion to draft the bill. Senator Kushner.
Senator Kushner votes yes.
Representative Sanchez.
Representative Sanchez votes yes.
Representative Wilson.
Representative Wilson votes yes.
Senator Cabrera. Senator Sampson.
Sampson is yes.
Representative Ackert.
Representative Ackert, yes.
Representative Hall.
Representative Hall, yes.
Representative Hughes.
Representative Hughes votes no.
Senator Lesser. Representative Weir. Representative Yakarino. Thank you, Madam Chair.
Thank you, and the votes will be held open. Moving now to agenda item number 4, bills for final action. We'll start with Senate Bill number 913, an act expanding workers' compensation coverage for post-traumatic stress injuries for all employees. This is a JF to the floor. Is there a motion?
So moved.
Is there a second?
Second.
It's been moved and seconded. Is there any discussion? Senator Sampson.
Thank you very much, Madam Chairman. This is a bill that would expand workers' compensation coverage for PTSI for all employees. Currently, we limit it to just certain types of first responders. I want to thank the chairs for this bill and say that this is something I'm very proud of what we've achieved in this committee in recent years. I think we've done a good job of expanding coverage for PTSI in ways that I didn't think were even achievable a few years ago. But I'm very pleased to see that this is moving forward. It's not without any concern whatsoever. Obviously, there was testimony from various interests about the potential cost of expanding this policy. But as long as we maintain the standard for what determines eligibility, I don't foresee a huge increase in the number of claims and a significant cost. I'm going to definitely support the bill because I believe in the underlying policy. I want to hope that the final product on the floor of the Senate is something that takes into consideration the potential costs and is done responsibly. And I'll just leave it right there for now. But thanks again to the chairs for bringing this bill forward. Thank you, Madam Chairman.
Thank you, Senator Sampson. And I agree with all of your remarks. I see that there's another hand. I believe it's Representative Ackert.
Thank you, Madam Chair. And, I'll work to move this to be drafted. I do have some concerns with it in certain industries, but when we see the language, I'd like to sit and chat with my Senate colleague, Rep. Sampson, and have a discussion with him on this. I did hear testimony, both sides, both opposing and strong support of it. So what I've asked for and have not seen is where these potential costs might be, because I don't think anybody's come up with that. I do have concerns overall. Workman's comp, we've been working in a great direction here in the state of Connecticut to lower the workman's comp cost for employers. And, we were not competitive years ago. We have done some good work in lowering these costs. So I'll support to be drafted. Doesn't mean I'm going to support the legislation moving forward, but I'd like to look forward to having more dialogue and conversation on this. And I would wish somebody would weigh in on what this potential cost may be, other than it's going to cost more, going to cost more, going to cost more. Well, how much is it going to cost? But I don't want it to have a negative effect. Obviously, we want to make sure that our employees are covered. But overall, what is the overall cost to the our towns and our businesses? So I look forward to moving this forward and seeing it drafted.
Thank you, Representative Ackert. And I do believe we will get some comment on that issue when the bill is drafted and Jay, and the bill is already drafted. When after we JF it to the floor, we will get remarks from OFA on any fiscal note will be generated on the bill. So you'll get that answer at some point. My suspicion is, as was stated by Senator Sampson, that this will be a very minimal cost, because the requirements that are set into the bill limit the cost in two different ways. First of all, the criteria for qualifying for workers' comp are very specific in terms of having witnessed or heard the death or dismemberment of an individual that you work with. And so these are not common occurrences. They're very specific criteria that have to be met. And then the other way that it is costs are limited is that the amount of benefits that are paid out are also have limitations, not the full workers' compensation benefits that you might receive in other kinds of qualifying claims. So I think you'll see that the fiscal note will be it will describe it as minimal if I'm just guessing. And it's not a wild guess. It's based on what we saw previously with regard to police and fire. And in fact, those occurrences are much more common, unfortunately, for police and fire to encounter. So I see that there's another hand in the room. Cameron, whose hand is up?
I believe that's Rep. Ackert with a follow-up question.
Representative Ackert.
No, just a follow-up comment. I incorrectly said move to draft. We're moving with JF in this out of this committee. So again, my support is to get this to a further conversation. So that's what I want to just correct my comments. That's all.
Thank you. So seeing no other hands, is this, I assume, is there any objection to a voice vote on this though?
There appears to be some objection to a voice vote.
Great, then.
Yeah. Excuse me. It has to be a roll call for
Oh,
final action.
Thank you. I'm sorry, I apologize. I should know that by now. So we will have a roll call vote. Cameron, will you please call the roll?
A roll call vote has been requested on agenda item 10 and a motion made and seconded. This is Senate Bill 913, an act expanding workers' compensation coverage for post-traumatic stress injuries for all employees. The motion is to JF this bill to the floor. Senator Kushner,
Senator Kushner votes yes.
Representative Sanchez,
Representative Sanchez votes yes.
Representative Wilson,
Representative Wilson votes yes.
Senator Cabrera, Senator Sampson,
Senator Sampson votes yes.
Representative Ackert,
Representative Acker votes yes.
Representative Hall,
Representative Hall votes yes.
Representative Hughes,
Representative Hughes votes yes.
Senator Lesser,
Senator Lesser votes yes.
Representative Weir,
Representative Weir is a no, pending further discussion and clarification on some language.
Representative Yacarino. Thank you, Madam Chair.
Thank you, and we will hold votes open. Next item on the agenda is Senate Bill number 937, an act providing workers' compensation benefits for certain cancers in firefighters. Is there a motion?
So moved.
It's been moved. Is there a second?
Second.
Okay, it's been moved and seconded. Is there any discussion? Senator Sampson.
Thank you, Madam Chairman. Yeah, so this is a bill that would effectively undo an arrangement and a deal that was struck in the past between the firefighters lobby and the municipalities that are affected and so forth. And for no other reason than that, I'm going to vote no, because I don't think that it's appropriate after years and years of discussion and debate and a failure for us to come to a conclusion. We finally did pass a law that everybody was happy with and that I thought moved the ball substantially in the favor of firefighters. And now there's a move to undo that agreement. The policy itself also presents a little bit of concern, because effectively what is being changed is this notion of creating something called a rebuttable presumption. And effectively that would mean that it's now going to be assumed that if a claim is made, that it's a legitimate claim, and there would have to be a rebuttal made by clear and convincing evidence that is what I'm reading in the language before that claim could be denied. That's a substantial departure from what had been agreed to. I also think that is a very significant and unusual provision in a policy like this. Anyway, the fact is, I mean, it's a difficult decision, and it's a very difficult situation, because obviously I think everyone on this committee wants to make sure that we do our best to protect all of our constituents, but in particular our first responders and our firefighters. But I think it's wrong to move a bill that undoes something that was agreed to in good faith by all the parties just very, very recently. And I've got to vote no on that reason and that reason alone. Thank you, Madam Chairman.
Thank you, Senator Sampson. I see another hand in the room.
I believe we have questions from both Representative Weir and Representative Ackert.
We'll start with Representative Ackert.
Thank you, Madam Chair. Mine is just to align my comments with the senator. That so much work went into this, and this wasn't, just a quick bill that got put together. This was years in the making. That we finally got to a good place on both sides last year, and I believe this was voted unanimously out of both chambers. And I think that's what, when you have something like that working in their favor, that you actually have that type of work, collaboration, and understanding of what we're doing here in the legislature, and just to, change that in less than a year, to me is not something I can support at this time.
Thank you, Representative Ackert. I do want to comment, respond to your comments. I believe the original deal that's being discussed was made some time ago, because it was prior to my coming to the legislature. It might have been 2015, 2016. In that time, the Cancer Relief Fund was established. Last year, we had concluded a task force on this issue and made a number of recommendations came out of that task force report. And there was great support and advocacy for a rebuttable presumption at that time. I think the reason why we found unanimity, we sought unanimity, is that we knew that the fund had been underfunded. Actually, the fund that was created originally had not received all the funds that it should have received during the years in between. And so part of what I think made it agreeable to folks was that there was an agreement to invest more funds in the Cancer Relief Fund. The problem that confronts us still remains, however, which is the deal that was struck was agreed to, I think, because it was far better than having nothing. But there is such a limitation on what can be paid out of the Cancer Relief Fund. Essentially, it's just paying wage replacement to firefighters. And that's not generally speaking, I'm told that's not the biggest issue that faces our firefighters when unfortunately they are diagnosed with cancer or eventually succumb to cancer. And so I think this bill is an effort to really fix the problem. And we've heard that it's a persistent problem. Even, having heard that one of our firefighters died the morning of the hearing, it was very disheartening that we weren't in a position to help his survivors more from the state of Connecticut and from our municipality. So, I know everybody wants to do the right thing here, but I just wanted to make sure people understood the nature of the deal that was struck and the reason why, the advocates have come back to us and said this continues to be a serious issue that needs to be addressed. So hopefully we will have a positive vote here today, and we'll continue discussion. Hopefully we'll win over unanimous support for this, because I do believe we're all have the same intentions, which is to make sure that we live up to our responsibilities to these brave men and women who, these brave people who fight fires and keep our communities safe in many other ways as well. So I know that there's another hand in the room. I believe it's Representative Weir.
Madam Chair, I just wanted to have a follow-up on that. I appreciate that
Sure.
dialogue. We'll again vote no at this, but it was last year that the piece that was removed was last year that we're adding back in, I believe. But we're gonna have further dialogue after this meeting and before we take it up on the House floor or the Senate floor, whichever is coming first. I think the Senate. But at this time, I'm gonna hold and flag this until I get more clarification. But I thank you for your response.
Thank you, Representative Ackert.
Actually, Representative Weir.
I'm sorry, Representative Weir. I'm sorry. I think this is one of the disadvantages of not being in the room, because I know the difference.
That's quite all right. Thank you, Madam Chair. I too heard the testimony, compelling testimony from firefighters talking about one of the gentlemen came and talked about losing his friend to a battle with cancer. I have had before and since then heard from two constituents, both in the fire service, who felt like the deal that was struck last year, the agreement, again, passed unanimously from my recollection in the Senate and when with one person in the House. Otherwise, it was almost unanimous in the House just 1 year ago. And these couple of people felt who are fire service members felt that this was going back on their word. So that was that's I guess I'm going to paraphrase, although one of them did use that terminology that I feel like we're going back on our word. So I guess that is definitely a concern of mine. And it is also my understanding, Madam Chair, that part of last year's agreement, there was supposed to be a report from the Labor Commissioner talking about how many people in the fire service might be affected by this, who may have fallen outside of workers' comp. And do we have information on how many people were affected? Meaning, if this law were to be changed to now, how many people would have benefited? There was supposed to be a report. It's my understanding, Madam Chair.
Thank you for that question. I believe the report was dependent on gathering incident information that we had not previously been requiring that the departments record that information. We certainly can ask DOL to produce a report if it has been done, but I'm not aware of any report at this time being ready. But I do think that's important information that we would like to gather. The incident reports, I think, just went into effect within the last year, so I'm not sure we've gotten enough information yet. To the question of the deal, I don't really want to, I apologize for prolonging the discussion, but I want to be very clear. I was the chair, the Senate chair at that time. It was a Senate bill. There was never a deal last year. There have been deals made between lobbying, advocate groups, all the stakeholders, and there was what I think we refer to as a deal originally before I came to the legislature to create the Cancer Relief Fund. Last year's task force, it was not a deal. It was a question of what could we get passed. I don't think any of the advocates really engaged and said, okay, let's make this deal. We're excited. We're happy. That was the case when we did the PTSI bill. And I was fortunate to be here the year we passed that. And it had been a result of, for police and fire, it had been the result of people coming to the table and coming up with an agreement on what both sides would support, and it went forward, and that was really productive. And I believe that was the case many years ago. I've been here 4 years. I believe that was the case with the creation of the Cancer Relief Fund, but it was not the case last year in terms of the task force on this issue. There was no deal. It was a question of what could we get passed last year that would put enough funds into the Cancer Relief Fund that would help us to be able to even handle the issue of payment of wages in the event someone qualified. But it wasn't recognized by the proponents of the firefighters organizations that we were working with. It was not recognized as a deal that would satisfy all their needs. And so I just want to make sure that, and I know, I'm happy to have further discussion offline with folks who are interested in that information, because I know you weren't participants in it directly. So, I don't expect you to have the same perspective as I do on what it was, but I do want to make sure that people are aware that, at least for my part and the part of, I think, others that served on that task force, it certainly wasn't considered a deal in the way other bills have come forward that really have met the needs of all parties. And so for that reason, I just wanted to make that clarification. At this time, if there are no other hands in the room, then I would.
There's a Rep. Weir has his hand up.
Sure.
So I just wanted to follow up, Madam Chair. So I thank you for that point of clarification. And so I will make sure that I am up to speed, that I have as much knowledge as possible on this subject. If there's something I'm missing for today, I'll be voting no, but I will commit myself to learning as much about this so that I can, have further discussion. Thank you.
Thank you. And I'm always anxious to have that conversation. So sometimes I run into you at the LOB. Let's make sure we talk about it a little more. So if there are no other hands in the room, then I will ask the clerk to call the roll.
A roll call vote has been requested and a motion made and seconded on agenda item 11. This is Senate Bill 937, an act providing workers' compensation benefits for certain cancers and firefighters. The motion is a JF to the floor. Senator Kushner,
Senator Kushner votes yes.
Representative Sanchez,
Representative Sanchez votes yes.
Representative Wilson,
Representative Wilson votes yes.
Senator Cabrera, Senator Sampson,
Sampson is no.
Representative Ackert,
Representative Acker votes no.
Representative Hall,
Representative Hall votes yes.
Representative Hughes,
Representative Hughes votes yes.
Senator Lesser, Representative Weir,
Representative Weirs, no.
Representative Yakarino. Thank you, Madam Chair.
Thank you. And we will be holding votes open. The next bill on our agenda is Senate Bill number 1035, an act concerning stop work orders. Is there a motion?
Rep Hughes, so moved. Oh, go ahead. Second, Darrell.
Okay, I heard Rep Wilson moved and seconded by Representative Hughes. Is there discussion? Senator Sampson.
Thank you, Madam Chairman. This is a bill regarding stop work orders. And really what it's about is about penalties. It's about increasing the penalties for the violation of such orders. Just looking through the bill, it looks like there's a few different provisions. One goes for 100 or 250 all the way up to, is it 1,000 or 5,000? I don't have it in front of me now. And then another one goes from 1,000 to 5,000. Anyway, these look like pretty substantial increases in the penalties. And I can certainly understand, if there's violations of something, we might come back and increase the penalties. But I have a few concerns. One is I don't know that I even agree with the concept of a stop work order for the violation of prevailing a wage. So I'd have trouble with the policy to begin with. But the bigger issue for me is it looks to me like the person who is responsible for determining whether someone violated such an order is the Commissioner of Labor. And it makes me really wonder about whether or not someone can receive true due process in a situation like this. Am I correct, Madam Chairman, that that's what happens? The commissioner is the one who does the investigation and determines whether a fine is levied, and then the actual state agency issues that fine. So it's not through a court or anything like that. And if that's true, what recourse does the person being fined have? Can they go to a court to fight such a such a fine, or do they have to exhaust their administrative appeal first or something like that? Can you just give me a little insight into the due process mechanism here through you, Madam Chairman?
Certainly, this is one area where it is a labor statute, and it is there is a process within the Department of Labor to investigate and issue the stop work orders. I don't know if LCO or OLR wants to comment more on the due process questions raised by the senator with regard to after. I assume you're asking if it is found that a company has violated the law, that then whether or not there's an appeal. But yes, the commissioner has the authority to institute the stop work order and the fine.
Well, I appreciate that answer. I think it's pretty clear from the language that the commissioner is the one that determines whether or not the fine is warranted. But I just know from experience that, generally speaking, when a state agency issues some type of fine or something for someone, the usual avenue that the person would have is that they've got to make an administrative appeal. If they try and go to court, usually the court pushes back and says you haven't exhausted your administrative options. And this just raises a big concern for me. I mean, we're talking about a state agency, which is going to be run by a commissioner who is a political appointment. And obviously you're talking about a politically charged issue in the sense of prevailing wage. And there are certainly people that are strong advocates for and against. And it just concerns me that we're going to empower the commissioner to be levying really substantial fines. And we're not giving a legitimate path of recourse or a proper method of due process to the person being fined. You know, I don't know that that was okay, even, you know, in current law, but at least the fines were not so substantial. Now you're talking about thousands of dollars. So I have serious concerns about that. If anybody on the committee has some additional information about how this might be litigated and what avenues a person being fined might have, I'd appreciate that information. But as it stands, I can't support it. Thank you, Madam Chairman.
Thank you. And I do want to point out that this has been in statute for a long time. And what we know from testimony we've had in the past and also from the DOL, that when these stop work orders are issued, generally speaking, the party that has been fined comes into compliance very quickly within 24 to 48 hours. So this really is one of those mechanisms we have in law to make sure that our effort is to try and deter employers from failing to meet their obligations under our labor statutes. And so in doing so, by raising the fine, I think the interest here is to make sure that the fine is substantial enough to actually act as the deterrent that we want it to be. I do think there's probably an appeal process to outside of the agency, but we can certainly get that information to you if we don't have it here with us today from someone in, I see Lee Hansen has popped in, so I'm guessing Lee has an answer to that.
Well, I just believe that it would follow the UAPA process the way other administrative violations would, the way Senator Sampson described.
Thank you. And I do want to also point out that this will bring us into compliance with other states. And it has, we haven't raised these fines since the law was first passed in the legislature. So that is the reason for this bill at this time. Senator Sampson, I think your hand is still up because you want to respond. No, it's down. Okay, I see Representative Hughes has her hand up.
Thank you, Madam Chair. I just want to comment that we did hear testimony that there is often egregious wage theft occurring, and that we need to empower these agencies and the commissioner to enforce the law and to, again, hold employers accountable that are just violating the law and saying, oh, well, the fine is just a part of doing business, and make it more of a deterrent. So that's the purpose of this.
Thank you, Representative. Next, I have Representative Ackert.
Thank you, Madam Chair. And I'm not really going to speak to the fines. I think that if somebody is in violation, that at some places, and I grant I'm not a big, fine the contractor, but stop work orders are designed for safety and making sure that our employees have coverage when on a job site. That's what's for workman's compensation. So that when an employer or a general contractor has their subs, they need to make sure that their subs have workman's compensation, or they're covering them through their policy. That's what the design of the stop work order was for. To expand it to pay right now, and I understand that we want to make sure they're being paid, but to stop a job because maybe a minor contractor on the job has come in and has violated the prevailing wage pay and benefits, should not stop a project. the project should move forward, then the wage enforcement should go in and work on that employer the subcontractor. It shouldn't stop a full project from to continue forward. That's my reservation right now. As I look into this a little bit more, and I think about it, what could possibly happen on a large project if a subcontractor isn't paying exactly the benefit component of the prevailing wage, and then all of a sudden the stop work order comes until that person is in compliance, it could be catastrophic to the project itself. It's not up to that general contractor to be the police for what somebody in office in that office is doing, how they're doing their payroll. They will have very little records of that. But I mean, they'll have as they submit their pay stubs to the appropriate authorities, then they may see that. But the whole goal of stop work orders is to make sure that an employee is on a job site or working and has complete and coverage for workman's compensation. That's the intent of the stop work orders, to my degree. So at this time, until I get to have further conversation, maybe I'm looking at it wrong, but I think I'm not. I'm going to be a no on this legislation.
Thank you, Representative. Next, we have Representative Weir.
Thank you, Madam Chair. And just to add upon what my colleague, Representative Ackert, mentioned, I have some experience working on prevailing wage projects, and I do see the stop work orders to be used in an area of safety where workers' safety is at risk. So I think that the wage issue could be addressed after the fact. And I just think of an example where a contractor perhaps may be out of compliance with wages, perhaps an electrician, or not an electrician, a plumber is perhaps out of compliance with the pay, and that trade is early on in the project, and further, so if there's a stop work order on that plumber, then the electricians and some of the other trades are not able to get in there. And that stops other contractors further down the line. And so my concern is, and again, we need to vet this out further, that could have an impact, on the project as a whole, but certainly other contractors down the line where a schedule has been set. Those schedules are precise, as well as precise as they can be. And you're affecting every contractor, every employee, and perhaps the end user, certainly if that project completion is delayed. And it seems to me that this could be dealt with perhaps through fines, and certainly retroactive rather than holding up the project. So for that, pending further information and conversation, I'm going to be a no today. Thank you, Madam Chair.
Thank you for your comments. And I don't see any other hands. So we will go ahead and ask the clerk to call the roll.
A roll call vote has been requested on agenda item 12, and a motion has been duly made and seconded. This is Senate Bill 1035, an act concerning stop work orders, and the motion is to JF this to the floor. Senator Kushner.
Senator Kushner votes yes.
Representative Sanchez.
Representative Sanchez votes yes.
Representative Wilson.
Representative Wilson votes yes.
Senator Cabrera. Senator Sampson.
Senator Sampson votes no.
Representative Ackert.
Representative Ackert votes no.
Representative Hall.
Representative Hall votes yes.
Representative Hughes.
Representative Hughes votes yes.
Senator Lesser. Representative Weir.
Representative Weir is no.
Representative Yacarino. Thank you, Madam Chair.
Thank you, and we will be holding votes open. The next item on our agenda is House Bill number 6549, an act concerning modification of and repealing obsolete provisions and statutes relevant to the Labor Department. Is there a motion? And this will be a JFS to the floor. I believe people have the substitute language.
Rep Hughes, seconded.
It's been moved and seconded. Is there any discussion? Seeing no hands, is there an objection to a voice vote on this item? On this motion? I'm sorry.
Has to be a roll call.
I know. I keep doing that, like I'm trying to get through this. I apologize. I even wrote myself a note, must have a roll call vote. I don't read my own notes. So we will take a roll call vote on this. Will the clerk please call the roll?
A roll call vote has been requested and a motion made and seconded on agenda item 13. House Bill 6549, an act concerning modification of and repealing obsolete provisions and statutes relevant to the Labor Department. The motion is a JFS to the floor. The substitute language is LCO 5111. Senator Kushner,
Senator Kushner votes yes.
Representative Sanchez,
Representative Sanchez votes yes.
Representative Wilson,
Representative Wilson votes yes.
Senator Cabrera, Senator Sampson,
Sampson votes yes.
Representative Ackert,
Representative Acker, yes.
Representative Hall,
Representative Hall, yes.
Representative Hughes,
Representative Hughes votes yes.
Senator Lesser, Representative Weir,
Representative Weir, yes.
Representative Yacarino. Thank you, Madam Chair.
Thank you for that, and we will hold the votes open. Moving on to the next item. House Bill 6720, an act concerning the state managerial employee definition for purposes of collective bargaining. And this is the JF to the floor.
Rep Hughes, so moved.
Is there a second?
Second.
Oh, I didn't hear you. I'm sorry.
It's okay. No worries.
It's been moved and seconded. Is there any comments or discussion? Cameron, who is there must be a hand up in the room.
That is Representative Ackert.
Representative Ackert.
Thank you, Madam Chair. And I have reservations on this one because if I'm not mistaken, under this governor's administration, he took a proactive approach to supporting the managers in state employment by co-aligning or aligning the raises in collective bargaining constituent in the units to make sure that the managers had the similar offset. So they're already getting that, and recently they've had some the raises that they deserve that took place recently the last couple of years. Again, these are very good paying jobs as I review some of them. So I'm not sure what this is trying to fix. They've got the state benefits, of course, which they don't need to bargain, they're typically like most state workers. And so I don't see, when I brought up the concern, I believe earlier, is that when they're in the conversation about, as managers, about collective bargaining for the units that they oversee, that it could create a problem that you might not bring in the managers, the commissioners, and deputy commissioners, and might not bring them in for conversation. So I have pause on this. I think this governor has already, I think, made the good move he needed for the managers in the state of Connecticut. So unless I'm missing something, I think that this has already been taken care of. And I think going forward, it should stay the same. So at this time, I'm a no on this legislation.
Thank you. I see Representative Hughes has her hand up.
Yeah, thank you, Madam Chair. This bill follows the same definition.
I'm sorry, you've muted yourself by accident here.
Thank you, Madam Chair. This bill follows the same definition as the higher education system. So it's allowing more groups of employees to access collective bargaining and certain rights and benefits. So it's inclusive of more people in that definition of manager, and that's why this bill is important. Thank you, Madam Chair.
Thank you. Are there any other hands in the room? If If there are no other hands, then I will
There
ask
is a hand up from Representative Weir.
Representative Weir.
Thank you, Madam Chair. And so as my colleague Representative Ackert pointed out that, the governor took a proactive response to addressing wage, I guess, disparities between managerial managers and also employees who are part of a collective bargaining unit. So it's my understanding, using that logic, that if the, if the employees, the non-managerial employees, bargain for a wage increase of, let's say, 3% or 4%, the manager who's overseeing, who will now, under this proposed legislation, would now be under their own collective bargaining unit. So it seems to me that a manager is going to, I think it would limit the input. I mean, if the manager stands to benefit from wages when the employees they're supervising go up. So if the employees go up 3 or 4%, the manager is going to go up 3 or 4%. I don't see why this would encourage anybody to bargain. And so I question how this will benefit the state, how the taxpayer is going to benefit, because these are the people we're answering to. So I think at the end of the day, I'm going to be a no on this. I don't see how this benefits our state as a whole. Thank you, Madam Chair.
Thank you for those comments. I do want to make my own comments at this point. I really appreciate what the action that Governor Lamont took in rectifying a very untenable situation where our managerial employees suffered from wage inversion, where they were actually making less than the people they were supervising in many instances, or they were paying more for their health care than the people they were supervising. It really was a deterrent to encouraging our state employees to take on promotions that would end up hurting them financially. So because it would hurt them financially is what I'm trying to say. But I don't think we want to depend on a governor to do this. This should be something that is within the employees, including managerial employees, ability to negotiate. To the question of whether or not managerial employees would be good negotiators if they were themselves going to benefit, my understanding of the CBAC negotiations that state employees engage in is that they are handled at a very high level. The managerial employees that would gain the right to bargain under this change in definition would not likely be in a position where they were actually the decision makers on a bargaining team representing the state. So that is my understanding. If I'm wrong about that, I'm happy to look at that question going forward after we move this bill along in the process. But that is my assumption. So if there are no other hands for comments, then I would ask the clerk to call the roll.
A roll call vote has been requested and a motion so made and seconded on agenda item 14. This is House Bill 6720, an act concerning the state managerial employee definition for purposes of collective bargaining. The motion is to JF this to the floor. Senator Kushner.
Senator Kushner votes yes.
Representative Sanchez.
Representative Sanchez votes yes.
Representative Wilson.
Representative Wilson votes yes.
I'm sorry, Representative Wilson, I didn't see you there.
Representative Wilson votes yes.
Senator Cabrera. Senator Sampson.
Senator Sampson votes no.
Representative Ackert.
Representative Ackert votes no.
Representative Hall.
Representative Hall votes yes.
Representative Hughes.
Representative Hughes votes yes.
Senator Lesser. Representative Weir.
Representative Weir is no.
Representative Yacarino. Thank you, Madam Chair.
Thank you. We will be holding votes open. Moving on to the final item on our agenda, House Bill number 6721, an act concerning workers' compensation and portal-to-portal coverage for telecommunicators. And this is a JFS to the floor. Is there a motion?
Rep Hughes, so moved.
Second.
It's been moved and seconded. Is there any discussion? Yes, Cameron, I assume there's someone in the room.
I believe Representative Weir has his hand up.
Yes, thank you, Madam Chair. And I want to know more about this bill and how other, for instance, this may not apply across the board, but if I think of doctors or nurses or, plumber being called into an emergency, this notion of being paid portal to portal, I need to understand more that a potential person would be covered leaving their home, coming into work in the result of an emergency. So for now, pending further information, I'm going to vote no. And as I learn more and the language is clarified and we have debate about it, I may change my position. Thank you.
Thank you. And just to for other members of the committee, and I'm certain, Representative Weir, that you're aware of this. This bill is only extending that portal-to-portal coverage to telecommunicators, and it is making that change because, as they testified to and have been testifying over recent years, they are part of the first responder team, and other first responders have that coverage. So that is the thinking behind it. But I appreciate your comments. Are there any other comments?
Just to follow up, Madam Chair, Representative Weir, if I may, as a former police officer, I worked shoulder to shoulder with the dispatchers and telecommunicators, as it's listed here, and I have the utmost respect for the job they did and do. When I went to any type of call, that dispatcher was, we relied on them at times, actually all the time, to provide us with up-to-date qualified information. They were looking out for us, and so I have the utmost respect. I just want to go on the record to say I need to understand more about this because they play an incredibly, immensely important role in the safety of our law enforcement and the public safety as a whole. Thank you, Madam Chair.
Thank you for those comments. If there are no other hands, then I will ask the clerk to call the roll.
A roll call vote has been requested and a motion made and seconded on agenda item 15, House Bill 6721, an act concerning workers' compensation and portal-to-portal coverage for telecommunicators. The motion is to JFS this bill to the floor. The substitute language is LCO 5110. Senator Kushner.
Senator Kushner votes yes.
Representative Sanchez.
Representative Sanchez votes yes.
Representative Wilson.
Representative Wilson votes yes.
Senator Cabrera. Senator Sampson.
Sampson is yes.
Representative Ackert.
Representative Ackert, yes.
Representative Hall.
Representative Hall, yes.
Representative Hughes.
Representative Hughes votes yes.
Senator Lesser. Representative Weir.
Representative Weir, no.
Representative Yacarino. Thank you, Madam Chair.
Thank you. And we will be holding votes open. I know that there are a number of members of our committee that are chairing other committee meetings or attending other committee meetings. So we will hold votes open until 2 p.m. I think that will be sufficient time. People can either go to the labor clerk's office, which is room 3800 in the Legislative Office Building, or can vote on this open line. We will be keeping this Zoom and YouTube line open until 2 p.m. At this time, there's no other business on our agenda, and I would just ask if my co-chair or ranking members would like to make any closing comments. Representative Sanchez.
Thank you.
Senator Sampson or Representative Ackert? Okay, great.
we look forward to having more people in the room next. I know the snow, get 4-wheel drives. No. Thank you, Madam Chair.
See, there he goes, bragging about his great vehicle again. No, I appreciate that. With no other comments, then I will just go to item 5, the announcement of time and date of our next meeting. We will be holding a Labor and Public Employees Committee public hearing Thursday, that is March 2nd at 12:30 p.m. in room 2B, and it will also be via Zoom. And with that, we will recess this meeting until 2 p.m. Thank you very much for everyone's participation.
Cameron, I think I missed a vote.
I will just go back through the list right now if you give me one moment here. Hang on. Just one moment, Representative Hughes. I've got a Representative Weir missed one and he's right in the room. Do you mind if I take his vote first?
Go ahead. Yeah, go ahead.
Okay, Representative Weir, the one I have you for is agenda item number 9. That is Senate Bill 831, a vote to draft.
Representative Weir votes yes.
Thank you. Okay. So Representative Hughes, I have you on. I have that you missed agenda item 6. That is proposed Senate Bill 21, a vote to draft.
Please count me as yes.
I believe that is the only one I do not have you recorded for.
Okay, thanks.
You're welcome.
Cameron, this is Representative Hall. I think I missed a few.
Okay, just give me one moment, please.
Sure.
Representative Hall, the only one I have that you missed is agenda item number 5, which is House Bill 6462. That is a vote to draft.
Yes.
Thank you very much.
Thank you.
Senator Cabrera.
Hey Cameron, how are you?
1 second, I can't hear you right now. I think that's just on my end though. Let me just quickly change that.
Okay.
Testing.
Yep, can you hear me?
I can hear you now, yeah.
Awesome.
Sorry, I have agenda item 5, that is 6462, a vote to draft. Would you like me to read the full titles?
Nope, I've got him.
In a second.
Senator Cabrera votes yes.
Okay. So then we have agenda item 6, Senate Bill 21, a vote to draft.
Senator Cabrera votes yes.
Agenda item 8, that is 489, vote to draft.
Senator Cabrera votes yes.
Agenda item 9, Senate Bill 831, vote to draft.
Senator Cabrera votes yes.
Okay. Agenda item 10, Senate Bill 913, JF to the floor.
Senator Cabrera votes yes.
Agenda item 11, Senate Bill 937, JF to the floor.
Senator Cabrera votes yes.
Agenda item 12, Senate Bill 1035, JF to the floor.
Senator Cabrera votes yes.
Agenda item 13, House Bill 6549, JFS to the floor with LCO 5111.
Senator Cabrera votes yes.
Item 14, House Bill 6720, JF to the floor.
Senator Cabrera votes yes.
And last but not least, item 15, House Bill 6721, JFS to the floor with LCO 5110.
Senator Cabrera votes yes.
Okay. Thank you very much, Senator.
Thanks, buddy. Appreciate it. Bye.
Oh. Hello, Senator Lesser.
Hi, Cameron. How are you?
Doing well. So I have 9 roll call votes here.
Mhm.
The first is agenda item 5, House Bill 6462. That is a vote to draft.
So moved. So sorry, so moved. My brain is dead. In the affirmative.
That's perfectly fine. Agenda item 6, that is Senate Bill 21, vote to draft.
Yes.
Agenda item 8, Senate Bill 489, vote to draft.
Yes.
Agenda item 9, Senate Bill 831, vote to draft.
Yes.
Okay. I have you on agenda item 10 already. So then we have agenda item 11, Senate Bill 913, JF to the floor.
Yes.
Agenda item 12, Senate Bill 1035, JF to the floor.
Yes.
Agenda item 13, House Bill 6549, JFS to the floor with LCO 5111.
Yes.
Item 14, House Bill 6720, JF to the floor.
Yes.
Okay. And agenda item 15, House Bill 6721, JFS to the floor with LCO 5110.
Yes.
Okay. Thank you very much, Senator.
Thank you.
Hi,
Only Representative
I'm
Iacarino.
sorry, I'm home recovering from surgery. I apologize for not being there, but
Sure, we all hope you're feeling better.
I hope so.
Okay, so I've got 10 roll call votes here. The first is on item 5, House Bill 6462. This is a vote to draft.
I'm a no on the first three, 5, 6, and 8.
To pull it up.
3, 8 could go either way, but hopefully we can fix it. So 5, 6, and 8, I'm a no.
Just give me 1 second here. I just have to mark this off. And 8. Sure. Okay. Got that. Okay, now item 9.
Yes.
That's a yes.
Yep.
Okay, just making sure. So now to the JFs. Item 10, 913 JF.
Yes.
Okay. Item 11, 937 JF.
Yes.
Item 12, 1035 JF.
I want to vote yes, but there's some issues. So no for now, and not that it matters, but hopefully yes in the future. But I'm a no.
13, 6549 JFS with.
Yes.
Okay.
Is that the Department of Labor? Yeah. I'm yes.
6720 JF.
No.
And
And
last one, 6721 JFS.
Yes.
Okay.
Thank you for
very
everything. Hopefully I'll see you next week. Bye.
much.
Bye. Cody.
Hello, Representative Acker.
Yeah, I'm gonna, oh, hey, so you gotta be on video,
Yes, you do. Yep.
so, change my no vote on.
That would be agenda item, oh, I'm on item 12, 1 second. Said agenda, 10:35, right?
Yeah, make sure.
So agenda item 10:35, that's agenda item 12,
Yep,
stop work orders.
yep, we're changing the name to
Mhm.
a yay.
Okay, I'm marking that in the correction field over here. Okay, thank you very much.
Thank you,
Representative.
Cameron.